Welcome back. So in this class, we're going to be discussing the exclusive rights of copyright owners. And in our previous class, we discussed copyright infringement, recognizing that a copyright is infringed whenever someone exercises, or rather a copyright is prima facie infringed whenever someone exercises one of the exclusive rights of a copyright owner without permission in such a way as to either use the work or create a new work that's substantially similar to the original work. But what are those exclusive rights of copyright owners, and how do they work in practice? So the exclusive rights of copyright owners are enumerated or provided for in Section 106 of the Copyright Act, which relates to the reproduction of copyrighted works, the preparation of derivative works, the distribution of copies of a work of authorship, or the public performance or display of a work of authorship, depending on whether it's a static work or a time-based work. So we can talk about the rights of reproduction, the right of adaptation, or the right to create derivative works based on a previously existing work, the right of distribution, and the rights of public performance and public display. So I'll just talk about each one of those briefly in order to kind of situate you in the rights and help you better understand what they do, how they do it, and why they exist in the first place. So the reproduction right is, of course, the most familiar of the exclusive rights of copyright owners. It's literally the right to create copies of the work of authorship in question. So, that's kind of how the right of copyright came into existence. In other words, the copyright was intended to give copyright owners the exclusive right to create copies of the works of authorship they either generated or purchased the right to make copies of from the author or some other owner of the copyright in the work in question. Now, the adaptation right, or the right to create derivative works, is closely related to the reproduction right, especially given how the Supreme Court and the lower courts currently conceptualize the subject matter of copyright protection. So essentially what the adaptation or derivative works rights provides is that the copyright owner has the exclusive right to make works based on the copyrighted work. And in practice, what that means is that the copyright owner has the exclusive right to create new works that incorporate some original element of the work of authorship in which they own a copyright. In other words, if you take some original element, some element of a work that can be and is protected by copyright and use it in a new work, then you have created a derivative work. Now, it's not necessarily an infringing derivative work, right? So the copyright owner still has to prove that the use was sufficiently substantial to constitute substantial similarity for the purpose of copyright infringement, and also that none of the exceptions, like fair use, would apply. But there could be a prima facie case for infringement of the derivative works right, so long as the copyright owner could show that the accused work included at least one original element from the copyright protected work that they own, such that the creator of the accused work had created a derivative work under the Copyright Act. Okay, now the distribution right provides the exclusive right to distribute copies of a work of authorship, and it's really important because it goes to the economic nature of copyright protection. In other words, we typically conceptualize copyright protection as reflecting the economic interests of authors and copyright owners in the works in which they own a copyright. And how do you monetize ownership of a copyright in a work of authorship? Well, by distributing or selling copies of the work in question to the public. Right? So frequently, infringement of the reproduction right might be hard to identify, or might be hard to police, or you might not even necessarily want to police certain kinds of reproductions, but copyright owners might care a lot more about infringements of the exclusive right to distribute copies of a work of authorship, because that's what their competitors would be doing, right? So the distribution right goes to the kind of competition-based element of copyright protection, saying that copyright owners have the exclusive right to produce the work of authorship in question and make it commercially available to the public. In other words, copyright owners have the monopoly on producing particular works of authorship in a commercial form, and that's protected by the distribution right. Now, the performance and display rights, or other public performance and public display rights, limit the performance or presentation of a work of authorship to the public. Similar to the distribution right, these go to the economic value of the work in question. In other words, a movie can be a valuable work to sell copies of, but it can also be a valuable thing to show to the public, right? Likewise, with a performance of a song, or even maybe like a reading of a book, or certainly the performance of a play, right? The presentation of a graphical work to the public, right? Those can all be very valuable uses of copyrighted works, and in certain circumstances, they're protected. However, they're limited to public performances and public displays. Why is that, right? Well, because if you're selling copies to people, it's for them to be able to use it on a private basis. And so private uses of copyrighted works of authorship can't be infringing, because then people wouldn't be able to use the copies. After all, if the performance and display right went to private uses, right, then reading a book in your house would be infringing, or reading a book to your kid would be infringing, because you would be performing or displaying the book to yourself, right? We want people to do that. In fact, that's why people buy those works of authorship in the first place, is to actually consume them. So it has to be the public performance or display, right? The use of the work in order to generate some kind of economic return, or at least the use of the work in a context that is like an economic use. Here you can see the definition of a derivative work, right? Which is a work based on one or more pre-existing works, right? Which has come to be interpreted in a pretty expansive way to include the use of any original element, right? And there's certain limitations on the exclusive rights of copyright owners. One important limitation on the distribution right is known as the first sale doctrine. Right? And what the first sale doctrine says is that the distribution right, the exclusive right to distribute copies of a work of authorship, is limited to the very first time that a particular copy of a work of authorship is distributed to the public. In other words, once the copyright owner has sold or otherwise transferred a particular copy, that particular copy is no longer subject to the distribution right. In other words, the copyright owner only controls the distribution the first time the copy is distributed, and subsequent to that, it's just a piece of property like any other piece of property that can be bought and sold in any way. Now, all of the other exclusive rights apply, right? So buying a copy of a work of authorship doesn't mean you're allowed to reproduce it. It doesn't mean you're allowed to create derivative works. It doesn't mean you're entitled to publicly perform or publicly display it, but it does mean you can resell that copy. Right? So that's why we have, say, used bookstores. It's why we used to have video rental stores, right? Because in a used bookstore, right, if a used bookstore buys a copy of a book from a consumer, well, they can do that because of the first sale doctrine, and they can resell it because of the first sale doctrine. Likewise, with a video store, once the video store bought the copy, bought the VHS tape, or bought the DVD from the consumer, the video store could then own that copy and rent it to other people, right? That was all a function of the first sale doctrine. Now, the problem now is that in the 21st century, we live in a digital world, right? And the question is, how, if at all, should the first sale doctrine apply to digital copies of works of authorship? In other words, is there such a thing as a digital first sale doctrine? For better or for worse, the answer seems to be, at least at this point, no. right? Because in a digital context, courts have interpreted the digital use or the transfer of a digital file from one computer or one location to another as a reproduction rather than a sale of a particular copy, right? For better or for worse, that means no first sale doctrine. It's not a distribution, it's a reproduction. Now, we experienced it in many cases as a distribution rather than a reproduction, but courts have gone with the reproduction model in part because they understand, or at least they have this intuition, that digital is different, right? That if we have a first sale doctrine when it comes to digital works, that'll be, at least in theory or potentially, could gut the meaning of copyright protection and make it essentially impossible for copyright owners to recover on many kinds of transactions that they would otherwise use, right? So, or that they would otherwise profit from. So essentially no digital first sale doctrine, although a lot of people think that's a problem. And many companies have made efforts to sort of create a ersatz digital first sale doctrine with, literally no meaningful success. Okay, and definition of public performance or display. It's to present a work to the public, right? Or to transmit a work to the public. And the transmission part will be relevant to the cases that you were asked to read for today. So Perfect 10 v. Amazon, of course, that's not the Perfect 10 we're talking about. It's this one, a magazine that was it published artistic photographs of women in state of undress, but of course everyone read it for the articles, I'm sure. In any case, Perfect 10, a magazine, bluntly, at least my understanding is, in bad economic shape when it came to the magazine itself, right? But running a website for members that was password protected for the content that they provided, and at least trying to make a profit via the website, but arguably also trying to make a profit by suing people copying and using their copyrighted photographs without their permission. In other words, Perfect 10, at least by all appearances, was kind of a early version of a what we call copyright troll, right? A company that was trying to use copyright protection primarily as a litigation tool rather than as a method of generating revenue from the works themselves. In other words, in any case, what happened? Well, a group of internet platforms, God knows who they were, many of them presumably based in Russia or some other country with limited regulation of internet activities, was going into the Perfect 10 website, downloading all the photographs and then posting them up on their own website and either selling them or giving ad space for free. Okay. So Perfect 10 was not happy about this. They didn't like the infringers. They wanted to do something about it, or they wanted to recover some money. But what did they do? They went after a bunch of other websites, third parties, including Google, which was the primary defendant in this case, saying that, in effect, you're facilitating this infringement, right? You're a secondary infringer because, or rather, you're making this infringement possible. And in fact, how you run your website is itself a form of infringement. Well, how is that? Google did two different things, right? One thing was, as you probably experienced, Google image search would troll the entire internet. If you put in a particular image search, it would come up with little thumbnail images of the photographs in which the copyright belonged to Perfect 10 and display them as part of the Google image search. Now, those thumbnail images were copied onto Google's servers to make the whole search process go faster and more efficiently. What happened when you clicked on the thumbnail? Well, it would open out into a new window and show you the image on the third party's website. In other words, it would show you the image at the URL attached to the thumbnail image that Google was showing you. Well, Perfect 10 says this is infringement twice over, right? You're infringing our reproduction right by making little copies, thumbnail copies of the images from these other websites that are infringing images, and they're still infringing when you copy it, even though the original infringer were these third parties. When you copy it, you're an infringer too. And then you infringe again by showing the images to consumers, right? You're showing them the full-size images, right? That's not only a reproduction right infringement, but a display right infringement as well. What's the value of these images? Is looking at them. Well, that's what you're doing. You're displaying these images to the public. Okay, well, ultimately, the Ninth Circuit rejected perfect tens arguments, right? It said, well, when it comes to the thumbnail images, we think that's not really an infringement of the reproduction right. They're super small, they're used in different contexts, and it effectively decided that on fair use grounds, which we'll get to later, right? But it also looked at the display right claim, and it said, is Google displaying the images that belong to perfect 10? And it said, no, not really. Or at least we're not going to interpret it as if Google is displaying the images that belong to perfect 10, because Google isn't copying the images. It's just creating a window, a new frame that's a window, in a sense, to the image on somebody else's website. In other words, Google isn't displaying the image. They're just showing you what somebody else is displaying on their website. Therefore, no display right infringement for Google. It's the other companies that are displaying it, not Google. Google's just giving you like a periscope to see through the internet to this other website. So they kind of use this very physical world analogy or metaphor to think about the nature of the service that Google is providing, saying Google copies the thumbnails, but it offers a window onto the full-size images, and the window isn't a display. It's just something you look through to see what's on the other side, like looking through the window of a store to see what's hanging on the wall, right? Something along those lines. Okay, well, may or may not find that a compelling analogy. We can think about it in the context of the ABC v. Aereo case. Oh, okay. So what happened here? Kind of a long, complicated backstory. But suffice it to say that what happened was when cable television technology was developed, or rather, prior to cable television technology, how did people see TV? Well, they saw with an antenna. It was broad. We call it broadcasting for a reason. TV signals were broadcast, just like radio was broadcast, and had an antenna on top of the TV. You tune the TV to the channel you want. You move the antenna around, try to get a better signal, so on and so forth. Well, that's, can be kind of inconvenient. And in addition, it really limits the amount of material you can get, because a broadcaster has to be close enough with a strong enough signal for you to get it. Also, enterprising individuals realized that this was not ideal for many consumers, and that, one way of solving this problem was for consumers to get television content via cable instead. So rather than broadcasting it, you get a cable come to your house that feeds you the information directly. But they're still broadcasting. And some enterprising individuals, especially in larger developments, said, well, why don't we just make one really big antenna and send that broadcast material to a bunch of different people? And the individuals, their argument was, well, look, every individual is entitled to have a TV antenna. We're just having one big TV antenna that everyone's sharing. It's the same thing. It's just a bunch of people using the same antenna. What's the problem? And the Supreme Court said, well, yeah, that seems to be right. You broadcast the signal, they get the signal, it goes to the people. They're just chipping in on one big antenna. That's no problem. So Congress actually changed the law and said, no, copyright is not going to allow the people who build these giant antennas to do this, right? We're going to kind of put a custom-made limitation into the Copyright Act. Okay, so this solves the problem from the broadcaster's perspective. Now they can just charge the cable companies for the content. Not great for consumers because everyone pays more money, but it's great for all the different people working in the industry, because now they know they can prevent people from getting something for nothing. Right? This is basically their concern. They don't want people to be able to get any content they want to without having to pay for it, or at least a broader range of content without having to pay for it. They want, although there's some content available via broadcast, they want you to still have to pay for content that's not coming from your broadcast area. Okay, so Aereo is a company that comes up with a brand new technology, right? And what does this technology do? Well, it consists of these networks of hundreds of thousands of tiny little antennas, right, that are set up to take in broadcast signals, right? And those tiny little free antennas, are then connected to a service that sends information to Aereo's customers, who are the ultimate consumers. So basically what Aereo has done is said, okay, you can't have one big tower that sends information to a whole bunch of different people. Our technology gives everyone their own antenna. Well, they're entitled to have their own antenna. Nothing says it has to be in their house, right? We just give them an antenna that's a long way away, and they come onto our site and they turn on their antenna and they say where they want to tune it, and then their antenna it's not our problem. We're just providing a technology. It's a technology that's great for consumers because it enables them to have a really great antenna all of their own, and that's still fine, right? So this comes to ultimately to the Supreme Court, and the question is, can Aereo do this, right? Well, what's the problem here? Essentially, Aereo's technology was developed explicitly or exclusively for the purpose of circumventing what the law had to say, right? In other words, Aereo's technology was designed precisely in order to avoid the legal restrictions that Congress had written into the Copyright Act via this fix to prevent people from providing broadcast cable. And the question was, can they do that, right? Can they circumvent the copyright law in that way? Well, a majority of the court said no. Essentially, if it looks like cable and it feels like cable and it quacks like cable, then it's cable. And we're not going to allow these kinds of technological workarounds to allow you to avoid the legal structure that Congress has imposed on this business. Whether or not we agree with what Congress did, ultimately that was their choice. And we're not going to allow you to create a technology that just sidesteps what the rules have to say. It's an infringing technology. But a significant minority of the court disagreed and said, look, we have to read these rules as they were written, right? And Aereo developed this technology in light of the rules that, Congress wrote and we interpreted, right? And how can we fault Aereo for investing in a technology that it had every reason to believe was perfectly legal because it fits within the letter of the law, right? So should we be saying that Aereo isn't entitled to provide this content, in a sense, to perform these, or rather, should we say that this is an infringement of the performance right insofar as Aereo is providing this content to consumers via these antennas, right? Simply because it looks like a giant antenna with cables going to a whole bunch of consumers, when the technology literally provides a individual antenna to each consumer, which is perfectly permissible and not a public performance, right? So is Aereo publicly performing by allowing consumers to have an antenna of this kind? That's not what the language of the law says. We should read the law literally and not read it analogically to say that, well, it looks like what Congress was trying to prohibit. In other words, the dissenters essentially say, look, if Congress wants to prohibit this, it can, but it hasn't done it yet. And it really ought to step forward and do it if it doesn't want Aereo to do this.